Hi, this is Richard Chamberlain, estate planning attorney in Perrysburg, Ohio. In this video, we're going to talk about how a revocable living trust will not protect your assets from a nursing home or from your potential creditors. Now, we're generally asked this question as we're sitting down with people talking about how to plan their estate, and we're talking about using a revocable living trust, which we do to avoid probate primarily and to also protect beneficiaries from their potential creditors and divorce and all the things that could happen. But the question comes up, well, does this revocable living trust protect our assets from our creditors? If we go into a nursing home, will our assets be protected if they're in this revocable living trust? And the answer is no, it won't. The way the revocable living trust is set up, the trustmaker is named the trustee of the trust. They're the person who's in charge of the trust assets. They're the beneficiary of the trust. So they don't give up any control over the trust assets. They can use them any way they want. They have complete access. They don't have any restrictions at all on their ability to get to or use the assets that are in the revocable living trust. So as a result, their creditors can also have that same access. They can force the trustmakers, who are also serving as the trustees, to get those assets out of the trust and use them to pay the trustmakers' debts. So the revocable living trust does not provide protection for your creditors or for your potential nursing home expenses. In order to get that kind of protection, you have to do one of two things. You have to either give the assets away, or you have to put them into an irrevocable trust. Now, we don't recommend that you give the assets away unless you are sure that you never want to have those assets again. If you give your assets away to your children, for example, then those assets are then available for their creditors, available to be spent, subject to, if they get divorced, any number of things could happen. If we're giving away assets so that they can be protected, then an irrevocable trust is a much more effective way to do that. With the irrevocable trust, the trustmaker does not serve as the trustee. Someone else is appointed the trustee of that irrevocable trust, generally one or more of the adult children. The trustee is not allowed to give assets from the trust to the trustmaker, although sometimes we do set it up so that the trustmaker can receive income, but not principal, income from those trust assets. Now, because the trustee cannot give principal from the trust to the trustmaker, those assets are not available for the trustmaker's creditors. So if they go into a nursing home, those assets are not available. If they have a judgment creditor, if they declare bankruptcy, then the assets in the irrevocable trust are not available to pay those debts. So if you have any questions about how to use a revocable living trust or an irrevocable trust to plan your estate, we invite you to give us a call at our office to schedule a free initial consultation with one of our attorneys. And we look forward to talking to you. Thank you.